Release item number 1.
Hey, please, Your Lordship. Your Lordship, I have filed one miscase
My lords, this is an order.
May it please your lordship, before my learned senior counsel submits lordship, if I may pray your lordship, if this matter may be taken up next week, lordship, as the learned DGI is indisposed, lordship.
There's an application for
it is only for if it is for
condonation first,
this is for condonation, is there?
Yes, yes.
Can you issue notice?
Yes, my lord. Here,
You accept notice?
Accept notice.
yes, my lord.
Condonation for what?
My lord, actually, there's a order passed by the cat, and then my lord, I've been aggrieved by that, and I've been pursuing to the. This comes from the National Institute of Film Fashion Technology, my lord, where I was employed
Do not go to
initially.
the, do not go to the
just
seriousness
try
of the
to-
thing.
yes,
Just
my
tell us how this condonation application comes.
Yes, my lord. So now, what happened is that, of course, in the limitation or under the Tribunals Act, my lord, there is no such mention of any specific provisions which says that challenge to the cat's order under Article 226 or 227. There is no specific limitation. However, it has to be filed within a reasonable time, my lord. It's a reasonable time. So just to take as a precaution, because there's little inordinate delay.
See, that is not the procedure. You cannot come by way of a separate application seeking condonation when there is no period prescribed.
My lord.
For how many days? Which way we will
Yes,
calculate?
normally,
you have given some calculation of 300 some days.
my lord,
See the office note here. It is blank here because they do not know how to compute it.
my lord, that's what I said, that I came as an abundant precaution only. Otherwise, different high courts has taken different way.
See,
I've
this is-
just
see.
yes.
This is Mr. There is an inherent wrong in your concept.
My lord.
The law of limitation or question of condonation doesn't arise. Writ petition is guided by the principles of delay and laches.
Yes, yes, my lord.
And if you find that there is a delay,
My
there
lord.
has to be an explanation in your main writ petition.
My lord,
Why
my-
delay has occurred.
My lord.
But then not by you are filing a separate condonation.
My lord. In fact,
is
my lord,
wrong.
in my writ petition, because I was also, my lord, this is the first case where I handle the cat's order. So I was doing a lot of
At least
research.
You know one thing,
Yes,
that law of limitation doesn't apply in writ
yes,
petition.
yes.
So that is good enough.
Good
Once
enough.
you know that. Two
Yes.
difference. One is law of limitation and one
Yes.
is principle of delay
Yes.
and laches.
But-
the principle of delay and laches which is
Yes.
applicable to writ petition.
But
not law of limitation.
My lord, I
But
quite
consideration,
follow. But some
consideration as far as sufficient cause is concerned
yes,
would be
yes,
the
my
same.
lord. But some high court took it as it has to be filed within 90 days. Some took it as review 30 days. Some took it as section 27.
Is there any specific period mentioned anywhere?
No, for 226 or 227 is not mentioned.
Your petition is under. So that is why
Yes,
this
yes.
court is.
Yes.
Still, I do not know subject to what my lord says.
Yes,
But then that is what the concept.
yes, my lord. So, my lord, in that view of the matter, my lord, let my main petition be listed on the next week. My lord, on the next date, my lord, and then
Have you made any specific averments in your main petition as far as what my brother was saying as far as delay and laches are concerned?
my lord, we have. My lord, there's one miss.
Because if you have, bifurcated those two issues, then if this petition is not considered, competition.
My lord, since it has been taken separately, so in the main petition that those not been mentioned.
You withdraw this and file fresh.
My lord, I'll do that, my lord.
Even you are senior counsel.
My lord,
You are not expected
oblige,
to
my
mix
lord.
it.
My lord, oblige. Because this is the first case I was going through some of the doing quite research, then it came out to this. But just to be in an abundant precaution side, I filed
That
this.
you can do, but then you make averments in the writ petition.
Yes, my lord.
Experiencing delay.
And while filing this also 327 days I did not give. I just said inordinate delay. But the registry was suggesting that how do we calculate?
No, but then we do not see any calculation by registry here. That is
Registry.
blank.
My
That
lord.
is why we see like this court has pointed out to you.
Yes, my lord.
Had there been any calculation, maybe
Yes, yes.
would have been single.
Yes. But my initial draft will see, my lord, is just written inordinate delay. but the main petition is not distinct today. It's only
The observation of my brother is correct.
my lord.
And we will not go into the academics of it.
Yes, yes, my lord.
You withdraw and
My lord. Well, I'll do that, my lord.
Mr. P. Owen, learned counsel for the petitioner. As I am to name.
Oh, my lord, there's one technical difficulty then, because this miss case is listed not a main case today. So I'm withdrawing this one, which means the main case.
In case he has not been admitted,
My lord, my lord.
not been taken to cognizance,
My
so
lord.
it goes.
My lord, my lord.
Until
Obliged.
unless the delay is condoned, so
Yes.
if there's a issue of delay,
My lord,
how can we take up the main?
my lord. Yes. Obliged.
supplementary list, item number 1 for pronouncement of judgment.
So there are two writ petitions.
Yes, Your Lordship.
I have passed a common order because facts are almost similar.
Similar.
I'll read only the operative
Yes,
portion.
Your Lordship.
Under the peculiar facts and circumstances of the case of the petitioners, as has been pointed out above, their absence from service was on a misplaced notion. However, technically, they are still officially engaged in the school run by the Roman Catholic Church, for which the school management, taking such facts into consideration, has initiated disciplinary action, including placing them under suspension. Therefore, it cannot be said that they have voluntarily or willfully abandoned their services. The case cited in this regard are found not to be applicable. Consequently, on appreciation of the totality of the case of the petitioners, this court is convinced that the authorities concerned have failed to proceed against the petitioners in accordance with relevant rules and procedure as far as the disciplinary action taken against them is concerned. Therefore, the petitioners have made out a case for this court to issue necessary direction to the authorities concerned. In the event, it is hereby directed that the said suspension order has become infructuous, the same is set aside and quashed. However, the authorities concerned are also directed to pay the arrears subsistence allowance to the petitioners from the period they have been placed under suspension till date. Thereafter, it would be open to the authorities to take up disciplinary proceedings against the petitioner if so warranted or so desired. The payment of the said subsistence allowance in terms of Rule 9 of the Service Rule for Employees of Government-Aided School, being 1/4 of the pay to be fixed by the managing committee, is to be disbursed to the petitioners respectively within 2 months from the date of this order. With the above, these petitions are hereby disposed of, no cost.
Obliged, Your Lordship.
Thank you.
Yes, Lordship. I beg to mention item number 2. I beg to mention item
DD
number
number 2, my lord. Hearing number 2.
Why?
Your Lordship, the conducting counsel has some personal difficulty, Your Lordship.
My lord, today I will join my friend for adjournment, my lord, because Mr. Subhashis Sen is also not available due to health issue, my lord. His missus is not well, my lord. So he's not been coming to office.
I'm for respondent 3, my lord.
I'm for 1, my
No
lord.
objection.
On joint prayer made by the Learned Council of the parties, matter is adjourned. This is the same after 2 weeks.
My lord.
On supplementary list, item number 2.
May it please Your Lordship. Your Lordship, I humbly pray that this matter may come up on Tuesday, Your Lordship, as learned DSGI is indisposed.
We have no objection, Lordship. Sir, writ petition, Lordship, challenging the...
Oh, but notice have not been issued.
Not yet, Lordship.
Then how can you make such a prayer?
Your Lordship, if
It is incumbent upon them to open the case, get notice to be issued.
Your Lordship, then...
You have jumped the gun.
No, Your Lordship, we've already been served a copy. We're representing the CBI.
They've been served a copy, Lordship.
True, they may have been served, but formally, an order has to be passed.
No, Lordship.
Your Lordship, it actually came in Justice Bhattacharya's court. He had recused the matter from there.
Okay. So earlier...
Yes,
matter-
Lordship.
Okay. Miss, on prayer made by Miss Learned Counsel for the respondent. Not objected to by Mr. Learned Counsel of the petitioner. That is adjourned. List is 29.
Much obliged.
Obliged, Lordship.
On daily list, item number 1.
Be pleased, my lord. My lord, I have filed an affidavit on behalf of the respondent number 5.
This matter is posted for this bench today.
Yes, Lordship.
It has travelled for quite some time before the coordinate
different
bench.
The other bench.
Then why was it?
On the last occasion, I think the private counsel has made some submissions before the coordinate court. As such, the matter has been recused.
What is the stage of it?
It's still pleading stage, Lordship. All
Pleading stage, my lord.
affidavits have been filed with respondents. We just require some time, Lordship, to peruse the affidavits if any rejoinder is required.
Okay.
This if your lordship recollect, this is a similar matter where my lord, 18th similar matter was been listed before this honorable court also. Whereby my lord, this is the order which has been passed by the one-man tribunal, my lord, against the challenge of election of the private respondent. That is the same of Malay, my lord. Same subject matter, my lord. There was a delay in filing of the election petition, so they have filed, that was allowed by this honorable court. Then I filed that delay application that was rejected. Against that they have come. In a similar case, in my case, in this particular case, it's just for 45 or 50 days. In my case, whereby I have come by way of the petition, in that case it was around 740 days. That was allowed. So it's a similar. So this is because Mr. Dengdo had raised Dengdo had raised, if your lordship recollect.
Oh, yes, sir.
Same case, my lord. The petitioner has come against the
Rejection order.
the rejection order, my lord. In my case, in this particular case, my lord, I have come against the allowing of the condonation. So Mr. Dengdo had submitted on the early occasion that since it's a tribunal, it should go to the executive committee, my lord.
Yes.
So same order, my lord. This is the same order. In this case also the appeal order has been passed by the tribunal only.
So you mean to say even in this matter we should leave it to the tribunal to take up the...
It's up to the petitioner, my lord. I'm just
At this juncture, Lordship, because Mr. Jeshala is the conducting counsel, kindly allow him to be present, Lordship, if any such
can be
instructions
listed
to be
together,
taken.
my lord, if that's the case. Same issues, my lord.
Mr. L. Karim, counsel for the for respondent.
For the respondent number 6, my lord.
Respondent number 6 has submitted that, has at the outset submitted that there is a similar matter pending before this court, being WPC number 2209 of 2025, involving the... In this, in your case, they are also parties
They are not parties,
No,
my lord,
Lordship.
but subject matter is the same. my lord.
Subject matter is the same.
involving the same subject matter as has been highlighted in this instant petition. For convenience sake, it is prayed that this matter may be taken up on the same date. The said WPC number 209 is fixed. When is it fixed?
4th August, my lord.
That is on 4th August. Then the counsel for the parties present at the bar has not made any objection to the prayers, to the submission made. Accordingly, this matter for consideration on 4th August. Once it is 4th August,
My lord. All right.
God bless you.
Item number 3.
Parties are not here.
Well, the other side is state.
State, but somebody has to be here. Because you see, this is a reference for mediation.
Correct.
So if parties agree, matter will be sent for. But if
in my humble submission, my lord, I don't think it will serve any purpose, because the nature of issue in the proceeding, my lord, is such that mediation perhaps will not help, my lord. So we can.
Parties are not agreeable for matters to be referred for mediation. Accordingly, the matter will remain in the list for further consideration for continuation of proceedings.
Item number 4.
Who's
Mr. Chaudhary is for the other side. This is that matter, my lord. It was a case of murder. A driver was murdered. His father filed a claim in the MSCT. MSCT passed an award. So our point is very simple: a murder cannot be a claim cannot arise out of a murder. An MSCT claim cannot arise out of a murder. So this matter, my lord, my humble submission is that it cannot be mediated.
See, for discussion's sake,
yes, ma'am.
If somebody is murdered in a car,
yes, ma'am,
and the car is, in motion,
yes, ma'am,
wouldn't that be death as a as a consequence of use of the vehicle?
The Supreme Court was quite clear that if the intention behind the crime is only the murder, then there is no MSCT claim that arises. But if the intention was something else, and it so happened that murder occurred, then you can file an MSCT case. Here in this,
if it is for hijacking or
yes, if somebody may want to steal the car, in the process of theft of the car, driver gets murdered, MSCT claim is maintainable. But if the intention of the offenders, the miscreants, was only to murder him, which is our case, then there is no claim that is maintainable. So maybe this matter may not be capable of being mediated.
Same order.
Item number 5.
May I please your lordship, for this instant case, we want to go for mediation, Your Honor.
This matter, my lord, it's a case of it's a case of the driver having no license. My friend represents the driver, so if there is no license, my lord, our submission was that we have no liability at all. Worst case, my lord, pay and recover has to be given to us. So even if it is sent for mediation, pay and recovery cannot be awarded by the mediator. It is honorable court only.
No, it's not question of.
Because it's a judicial order that has to be passed, allowing me to pay and recover. The first ground is obviously that we have no liability at all. That is arguable.
No, let's put it this way.
Yes,
I don't recall. You see, if any effective order in those lines can be passed. But suppose.
Yes, ma'am.
You see, why mediation is to cut short the process.
My lord.
And also based on the understanding between the parties.
My lord.
So, in principle, if you have agreed that yes, you are liable to pay and recover, and they would agree to that.
My lord. My lord.
So the mediator will note it down.
My lord.
The parties have upon deliberation, parties have agreed, and it is proposed or suggested that the insurance company will pay the compensation and recover. For that, you have to, of course, you have to go through several proceedings.
Understood.
So
Understood.
I completely
understood. I completely appreciate what is falling from my lord. My lord, if this was a case of fake license, then maybe we'd be completely satisfied with the pay and recovery being granted to us. So if that is recorded in the mediation, and it comes back to my lord can pass a formal order allowing us to pay and recover. But unfortunately, my lord, this is not a case of fake license, it's a case of no license. So in a case of no license, the first submission is that there is no liability. So pay and recovery is not a solace for us. We have no liability at all. Worst case, pay and recovery has to be granted to us. So that first aspect, my lord, may require a judicial determination, my lord. Because our submission is that we have no liability. Obviously, the other side has the opposite submission, my lord.
So, if there is no consensus, we cannot force mediation. Same. Pass order in the same line.
Item number 6.
Yeah, Lordship, this mediation will not be feasible.
They are disputing their liability itself. So otherwise the matter is already heard.
Yeah, no,
I have concluded.
That's beside the point. It has been listed today for consideration of
seeing the feasibility.
Seek instruction. My instruction is that it's not feasible.
Fine.
Matter your lordship already date will be same. What is
same. It goes. It will. The matter will retain its position in the list.
Yes.
Item number 7.
Your Lordship, this method, Mr. B.K. Singh appears, Your Lordship, for the petitioner appellant. Your Lordship, seek instructions, Your Lordship. We are not going into mediation, Your Lordship. That's my instructions.
None appears for the appellant. Mr. General Counsel for the respondent, 3 and 4, has submitted that he is instructed by his client that this matter will not be possible to be resolved through mediation. Accordingly, matter will retain its position in the list.
Obliged.
Item number 8.
This matter, my lord, I'm happy to submit that it can be sent for mediation.
Learned counsel for the parties, Mr. S. General, learned counsel for the appellant, as well as Mr. H. Hajarika, learned counsel for the respondent, has jointly submitted that on being instructed, this matter is, there is possibility for this matter to be settled through mediation. Accordingly, that is now, and matter is now referred for mediation. Formal notice will be issued upon the parties. Let's hope it's, you can, what is it?
This one we can, I think we can. This one we can.
Right.
Item number 9.
This one, unfortunately, I don't think can be mediated.
Yes, madam. We'll go for hearing.
What is this case about?
It's actually a case of our driver, our insured vehicles driver, motorcycle. He was holding a learner's license. So a learner's license requires, as per motor vehicle rules, requires you to be accompanied by a person holding a proper license, a full license. In this case, that was not the case. So he was holding a learner's license without being accompanied by anyone holding a proper license. So in other words, he had no license. He had no license. So for submission, like the previous case, my lord, we have no liability. That is the sum total of our case, my lord.
So I'll pass the same orders
Very well.
like the previous one.
Very well. Obliged.
Item number 10.
Mr. Bora is not.
Mr. Barwa is not there, Your Lordship.
Miss Ainua, that G appears for the petitioner. None appears for the respondent. Accordingly, process for mediation cannot be initiated in absence of one of the parties. Efforts will be one of the party. Accordingly, similar I don't think this matter can also go for
Yes, Your
most
Lordship.
probably. Under such circumstances, no formal order, no effective order can be passed today. Matter shall remain, shall retain its position in the list.
Much obliged, Lordship.
Item number 11.
Oh, yes, sir.
Lordship, this cannot go to mediation. This cannot go to mediation.
Why?
Lordship, this matter pertains to Mexilton Estate. Our ground is that the
Oh, this-
land acquisition matter has already lapsed, Lordship.
Okay, that connected with
Krishna Boy,
Yes, Your
there's
Lordship.
another matter. This cannot go, Lordship.
Then the counsel for the parties has submitted at the bar that on being so instructed, parties are not willing for this matter to be referred for mediation. Accordingly, matter shall retain, matter shall retain its position in the list.
Much obliged, Lordship.
Item number 12.
Right, please, Your Lordship. Lordship, in this matter, I am under instructions that the respondent does not want to pursue mediation in this matter.
This is with regard to the execution matter.
My lord, yes. Here, what has happened, my lord, the vacant possession has already been handed over to the decree holder. But again, they have filed an application for removal of records. So subsequent application has been filed. So against that, we have challenged.
Removal of what?
The articles, my lord, which has been lying in the suit premises.
You have not done that.
My lord, that has been done because against that, they have filed another application, my lord.
Why? You see, if a certain suit premises,
Yes.
which is has been decided,
Yes.
degree pass, execution carried,
My lord.
everything said and done. So you have even vacated the
Yeah, vacated.
premises. So thereafter they have taken up another execution.
My lord, they have filed another application for direction to remove all those goods and articles, which was
But you
subsequently
said you
allowed.
have already.
My lord, here what has happened? Because the law says that, my lord, once the vacant possession has already been handed over to the decree holder. So, for the subsequent application, it has to be by way of a fresh suit, not by way of any misapplication. So that's our contention, my lord.
The matter has to be heard, my lord.
Anyway, since they don't want for any mediation, then, my lord, then the lordships can have it.
Even why are you resisting? You see, mediation means what? You see,
this is a landlord
mediation
tenant
what? If you go
dispute.
for mediation, the matter can be resolved. You see, I don't think they will resist since they have been ousted from the suit premises. What is there? They are no longer in possession. So only if you say it concerns some articles or some materials, whatever that is available there, which supposedly belongs to them, then you can just
No,
I mean,
exactly.
put it simply, you see, you can just tell them remove it, and that's all.
And I will fairly concede that I am not very well versed with the facts of the case. My learned senior will be able to apprise my lord.
But Mr. Sawa is very clear on this.
Lordship may kindly have it for hearing, my lord, because the respondent is not willing to go for mediation.
Okay. Mr. The counsel for the petitioner has submitted that the petitioner is willing for this matter to be referred for mediation. However, Mr. Ahmed, learned counsel for the respondent, has submitted that he is instructed by his client that they are not willing for settlement of this matter through mediation and would await the decision of this court upon accordingly, since matter could not be referred for mediation, the same will retain its position in the list.
Much appreciated.